Most people hear the word settlement and translate it into a simple win or a simple loss. That is not how law works. In the next few minutes, I'll explain what a settlement actually is, what it can tell us, and what it absolutely does not prove. No hot takes, just court clarity and context. We're doing this in 5 parts. Part 1, what a settlement is in plain language. Part 2, why cases settle even when someone believes they would win. Part 3, what a settlement can include. Part 4, what it does not mean. Part 5, a simple checklist for reading settlement headlines without getting manipulated. 1. What a settlement is. A settlement is an agreement between parties that brings a legal dispute to an end and typically results in the voluntary dismissal of the lawsuit. Instead of continuing through a full trial where a judge, and sometimes a jury, would hear evidence and issue a ruling, the parties negotiate terms they both accept and then formally close the case. The court's role becomes administrative at that stage, entering the dismissal based on the agreement reached. That is the first clarity point. A settlement is not a verdict. It does not represent a judge's final determination after weighing all the evidence in open court. It is a resolution crafted by the parties themselves. It may reflect compromise, risk assessment, cost considerations, reputational concerns, or strategic decisions about uncertainty. Trials are unpredictable, expensive, and public. Settlements trade that uncertainty for control and closure. The second clarity point is that many settlements function as private contracts. The detailed terms are often confidential. In some cases, the only information made public is that the matter has settled, that damages were paid, or that a statement or apology was issued. The finer details, financial figures, internal acknowledgements, or negotiated language may remain between the parties unless they choose to disclose them. So if you are following media coverage and feel like you are only seeing part of the picture, that perception can be accurate. The public often has access to only a limited window into the agreement. Courts generally respect confidentiality clauses in settlements, and unless disclosure is required, the full terms may never be published. That is not evidence of secrecy in a dramatic sense, and it is not automatically a sign of wrongdoing. It is a common structural feature of how civil disputes are resolved. Settlements prioritize finality and mutual agreement, not full public exposition. 2. Why cases settle. People assume that if someone settles, they must be guilty, or scared, or lying. That is not necessarily true. Here are the most common reasons cases settle, even when both sides feel confident. Reason 1, cost and risk. Trials are expensive and unpredictable. Even strong cases have risk. Settlement buys certainty. Reason 2, time and stress. Litigation can take years. For public figures, it can also keep a controversy alive. Settlement ends the cycle. Reason 3, evidence and exposure. Sometimes both sides want to avoid a full public trial where private documents, messages, or internal processes might become part of the public record. Reason 4, narrow legal issues. A case can hinge on complex or technical legal rules where the outcome may depend on a single key question of law or procedure. In such situations, one party might choose to settle rather than gamble on an uncertain ruling, avoiding the risk of an unfavourable judgment even if they believe their position has merit. Settling allows them to control the outcome and minimise potential losses. Reason 5, reputational management. This is the one most people misunderstand. Reputation does not only mean guilt. It can mean choosing a quieter ending rather than a longer public fight. So settlement is often a rational decision. It's not automatically a confession, and it's not automatically a victory lap either. 3. What a settlement can include. If you want to understand a settlement, focus on what it actually contains. Here are common settlement elements. Money and costs. Payment in a settlement can include financial damages for harm caused, reimbursement of legal costs, or sometimes both. This may cover compensation for actual losses, emotional distress, reputational harm, and the expenses involved in pursuing or defending the case in court. In addition, settlements can sometimes include interest, punitive amounts, or other negotiated payments designed to fully resolve the dispute and prevent further claims. The exact payment terms vary depending on the nature of the case, the parties' bargaining positions, and the goals of the settlement, making each agreement unique. A statement or apology. Sometimes a settlement includes a public statement, clarification, apology, or an agreement to remove, correct, or retract content. These statements can be important because they become part of the official public record, showing what the parties agreed to and helping clarify the situation for the public or protect reputations. A release of claims. This is a key point. A settlement usually includes a release, which is a legal agreement where one or both sides promise not to continue the current claim or to bring any related claims in the future. This release provides finality, protecting the parties from ongoing or future legal disputes arising from the same issue, and is often a central reason why settlements are appealing to both sides. Confidentiality. Many settlements include confidentiality clauses, which means the specific terms such as payment amounts, actions to be taken, deadlines, or other conditions are often kept private and not disclosed to the public. This confidentiality protects the parties' privacy, reputations, and sensitive information, but it also makes it difficult for outsiders to fully understand what was agreed upon. As a result, any reports or headlines about a settlement may only tell part of the story, and the actual details could differ significantly from what is publicly suggested. No admission of liability. Many settlements include language that says the settlement is not an admission of wrongdoing. That clause exists because parties often want resolution without conceding fault. So when you read about a settlement, the useful question is not who won. The useful question is, what did the parties agree to do, say, pay, stop doing, or correct? 4. What a settlement does not mean. This is where we protect ourselves from being misled. A settlement does not equal a court finding. A court finding occurs after evidence is thoroughly examined during a trial, and a judge reaches formal conclusions based on that evidence. In contrast, a settlement halts that process, allowing the parties to resolve the dispute privately without a trial, verdict, or formal determination of guilt or liability. A settlement does not automatically prove guilt. Because settlements often include no admission of wrongdoing language, and because they are frequently motivated by factors such as cost, risk, time, and the desire for privacy, they should not be treated as reliable proof of wrongdoing. Settling a case allows parties to avoid the uncertainty, expense, and publicity of a trial, and does not indicate guilt or legal fault. In many instances, a settlement is simply a practical decision to resolve a dispute efficiently, without creating a formal judgment or record of liability. A settlement does not automatically prove innocence. Also important, a settlement is not a certificate of innocence, it is simply a negotiated resolution between the parties. Some people settle to avoid financial or legal risk, while others settle because they believe the other side has a strong case, or to save time, stress, or public exposure. The motivations for settling can vary widely, which is why a settlement alone does not prove guilt or innocence. A settlement does not tell you the full story by itself. If the terms of a settlement are confidential, the public may not know the exact amount paid or the specific details of the agreement. This means that anyone claiming absolute certainty or drawing firm conclusions based solely on a settlement headline is usually overstating what can be known. Settlements can be complex, and the full context is often hidden from view. So the honest position is this: a settlement is informative but limited. It tells you the parties resolved the dispute. It may tell you what was agreed publicly. It does not give you the full evidentiary picture the way a judgment does. 5. How to read settlement headlines like a pro. Here is the simple checklist I want you to use every time you see a settlement story. Step 1. Identify the type of outcome. Is this a settlement, a judgment, or a dismissal? Those are different. Step 2. Look for what is actually on the record. Was there a public statement? An apology? A correction? A removal? If yes, that's meaningful. Step 3. Notice the language. If you see without admission of liability, that's not a loophole. That's a standard legal structure that prevents people from treating the settlement itself as an admission. Step 4. Ask what changed. Did content come down? Was there an agreed clarification? Did the case end with a promise about future conduct? That's your practical outcome. Step 5. Resist the emotional translation. Headlines often try to make you feel like settlement equals guilt or settlement equals vindication. The reality is usually more precise and more boring. And boring is where accuracy lives. That's the core of media literacy. We don't react to the word settlement, we read what the settlement does. A settlement is an agreement that ends a dispute, usually without a full trial decision. It can include money, costs, confidentiality, and public statements, often with no admission of liability language. And it does not automatically prove guilt or innocence, it proves resolution. So the method remains the same. Claim. Evidence. Outcome. And settlement is one kind of outcome. If you want more calm court clarity and media literacy breakdowns, subscribe and check the Court Explained playlist. And comment with the next term you want unpacked: judgment, appeal, injunction, or damages.